Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice Sabita Singh, and joining us by Zoom is Justice Maureen Walsh. We'll be your panel for the two cases today. If you've been to the Appeals Court before, you know we give 15 minutes per side. We don't have time for rebuttal. We've read your briefs. We've read the pertinent parts of the record, and we know what the arguments are, so I would encourage each of you to get directly to your the key parts of your argument. We don't need the factual background or the procedural background for the most part. So with that, I'll call the first case, number 23P50, Commonwealth versus Kevin M. Tinan. Mr. Madison.
Good morning, and may it please the Court. Nick Madison for Kevin Tinan. In this case, Mr. Tinan received ineffective assistance of his plea counsel, both where his plea counsel failed to investigate and advise him about a viable motion to suppress, and where his counsel affirmatively provided erroneous advice on the length of time Mr. Tinan would serve. Turning first to the motion to suppress aspect of this case, I think it's important to begin by responding to the Commonwealth's argument that the foregoing a motion to suppress in this case was strategic. This misunderstands the role that strategic decisions play in effective assistance jurisprudence. In this case, counsel never investigated a motion, the factual background of a motion to suppress, never obtained this or reviewed the search warrants. And so she can't have said to have made a strategic decision to forego a motion to suppress.
I wanted to ask about that. Was there time pressure vis-a-vis the Vermont charges such that if the Massachusetts charges didn't move toward a resolution quickly, there was more of a chance that Vermont would get him, quote unquote, as to quote the defense counsel's affidavit, so that it might have been in the defendant's interest to plead quickly rather than going through the time that would be required to investigate and possibly file a motion to suppress?
There's nothing in the record to suggest that, Your Honor. Mr. Tinan, the docket reflects, was held on bail. There was a detainer lodged behind him from Vermont while he was in custody in Massachusetts, but Mr. Tinan wasn't going anywhere so long as the cases here were pending and or he was in custody pursuant to a sentence here.
So as long as he was in custody, there was no risk that Vermont could take him away and try him and send him to state prison out of state for 4 to 5 years?
That's correct. Not while he was held on bail while the case was pending or while he was serving a sentence. And there's a second
Counsel, let me interrupt for a moment. I would tend to agree with you in the sense that I think the affidavit by trial counsel makes it so that the analysis cannot be strategic, right? Even though all roads point to strategy, and in a very effective strategy, I might say, about her predicting what other states, in particular Vermont, would do and how to avoid a state prison sentence that was not going to be served in Vermont and was going to be served someplace else. So while certainly you get the flavor of strategy in many aspects of this attorney's representation, I tend to agree with you that because the way that it's framed in the affidavit, there's no evidence, my point of view, that we could say this was strategic. Okay, so if we accept that it's not strategic, let's move on to your argument in substance.
Certainly, Justice Walsh. So moving on to the substance, the motion to suppress under Leslie was certainly viable. Leslie, of course, had substantially analogous facts about what is curtilage on a multi-unit living residence, a multi-unit living situation.
And you only need to show viability, not that it would have succeeded.
For the purposes of deficient performance, we need to show that the motion was viable. For the purposes of establishing prejudice, there needs to be a reasonable likelihood that the motion would have succeeded. And so...
And let me interrupt again, and I know it's awkward, and you're doing a great job, counsel, at kind of playing this ping pong with video. You cite to Leslie. Do you have any case in which a detached, shared garage / some sort of building the court has found to be curtilage?
So I could refer, not a detached, a case where a garage or a shed or some external structure, one isn't coming to mind. Well, no, let me, in Collins v. Virginia, that's a recent Supreme Court case cited in my brief. In that case, there was I believe it was described as a carport. It was enclosed on it was open to a driveway on one side and enclosed on two sides by a wall and a third side by the exterior wall of a building.
So directly adjacent to the house.
Directly adjacent to the house, and that was, that isn't a garage as such, but it's an external structure that the court found to be curtilage. I would also note in driveways have been established to be curtilage. The Fernandez case comes to mind, in which a driveway adjacent to a house was determined to have been curtilage.
But as I look, I mean, curtilage, whether it's curtilage is a question of law. Is that correct? Or, I mean, the facts underlying that determination would obviously be factual questions, but how do we evaluate the judge's decision that this was not curtilage, or what he seems to have concluded?
Certainly, Your Honor. I think it might be best described as a mixed question of fact and law. It is a fact-bound determination, clearly, that involves weighing the four, what are known, the Dunn factors, and then applying that to a relatively general standard of, is it the sort of space that is sufficiently
associated with the home, immediately
Yes.
surrounding and associated with the home.
Exactly,
So
Your
as
Honor.
I look at the photos in the record, it seems that the garage was cut off from the home by the backyard, by the gardens, by the other vegetation. The backyard might very well have been curtilage, but that's not the issue here. The issue, as I understand it, is the area in front of the garage doors where the sergeant stood and looked through the windows.
well.
And if that's not curtilage, then could the motion have succeeded?
Yes, Your Honor, because from the diagram and the photographs, you can see that Sergeant Zoito, I believe, would have had to have walked up the driveway, past any of the entrances to the house, into the parking area, and then across the parking area and up to the garage. So if any part of that path was part of the curtilage, there would have been an intrusion of the curtilage, and Mr. Tinan could have succeeded on that theory.
What case says that if there's an intrusion on the curtilage in order to get to some place that's not curtilage, then the intrusion is invalid, or the officer wasn't lawfully in the spot from which he made the observations?
In Hardines v. Florida, the court describes that the nature of the intrusion is both that the intrusion has both spatial and limit salience. That's not a great way of describing it, but essentially that you need to be within the curtilage for a purpose to investigate. And so an intrusion into the curtilage for the purpose of investigation per Hardines is...
Counsel, I mean, that's a stretch, wouldn't you say? I mean, you know, I appreciate many of your arguments. This one, that case law is really related to when the police bang through the front door and shouldn't have been there in the first place, and then walk out to some place that isn't curtilage. That initial violation voids arrest, for lack of a better word. I mean, this is not that type of case, right? I mean, there's no case law that I've found that says an officer walking on a driveway who sees something that the question is whether it is included in the curtilage or not, that everything has to be suppressed.
Well, I won't put too much weight to that point, other than to say if any part of that is determined to be curtilage, I suppose it also lends more force to the further you get back into the property, the more removed you are from the street, that would favor a finding that towards the back of the property is curtilage as well.
What about the argument that even if the motion to suppress may have been viable and potentially successful, that they had probable cause based upon the first search warrant, based upon the intervening Vermont arrest, to have that GPS locator put and right where it was? I mean, what do you say about that argument?
Certainly, Your Honor. So there's a few responses to that. First of all, as to the Commonwealth's argument that there was probable cause apart from the unlawful entry, that ignores the nexus requirement. So they had the Commonwealth had to have probable cause both that the car was evidence and where it was likely to be found. The police officers in this case did not have probable cause as to where it would be found apart from the unlawful entry in which they discovered the location of the car and then went to get search warrants. And then my other response to that would be the Commonwealth's suggestion of that you could merely strike any observations from the subsequent search warrant applications and then see if there was probable cause is not the proper analysis. That would be the analysis for a Franks violation, which is the case to which they cited for the support of that. But the question there would be, was there an independent source apart from the unlawful entry? The Supreme Judicial Court's recent case of Pearson describes that. There would have to be a finding that both there was probable cause without the observations made during the unlawful entry and what they saw during the unlawful entry didn't prompt them to go get a search warrant, which by the face of the affidavits, here is exactly what happened.
For your argument that the officer wasn't lawfully in the position to observe the car in the garage, you rely on the curtilage argument. You don't seem to rely in your brief, unless I missed it, on the idea that even if it wasn't curtilage, your client had a reasonable expectation of privacy in the area in front of the garage from which the officer made his observation, or the garage itself, if we read the affidavit to say that the officer actually opened the door a little bit.
Yes, Your Honor. In my reply, I certainly didn't put weight on the reasonable expectation of privacy argument. I did, I believe, raise it in my reply brief that Mr. Tinan could succeed either if there was a reasonable expectation of privacy established in the garage or if there was an unlawful entry into curtilage. If I may briefly, I would just like to raise two quick arguments as to the second claim regarding the length of the sentence. There were two conflations that I think are important to point out. The first is the difference between advice on parole eligibility and advice on the length of the sentence that somebody would actually serve, a defendant would actually serve. In this case, if you look at counsel's affidavit and the defendant's affidavit, both of them state that the advice was to the length of the sentence that the defendant would actually serve, not when he would be eligible. And that's a salient difference because it's taking the intermediate agency of the parole board out of the equation and saying this is when you will be released. And I believe that's the only way to understand how counsel phrased the advice that she provided in her affidavit, that Mr. Tinan was virtually certain to receive parole. The other
let me interrupt for a moment on that point because I think it's important. a number of cases talk about parole eligibility being collateral, and your argument is that that's different than this case, which is a bad advice saying you're going to get out in 9 months, right? So if I can agree with you for a moment that lawyers ought not predict what is an unpredictable system of releasing incarcerated offenders, how is it not collateral? So in other words, and it's really still down to the length of the sentence. In Morrow, the counsel gave bad advice as to when the person would be eligible, right? And they had to serve an extra 18 months in jail. And the court said, that's collateral. It wasn't just eligibility. It was like, that plea was based upon a belief that I had a possibility of release. Here, the defendant actually got a hearing. And I read the decision, so one is, how is it not collateral? Two is a decision based the denial on a number of factors. Again, predictive in the future. He had a chance at it. He didn't get it. And many of those things, one of the three reasons was the outstanding warrant, but it wasn't the sole reason.
I see my time has expired. May I respond? Briefly.
Please.
First, the detainers from Vermont existed, and that there may have been other factors that were responsive to that had the effect of him being denied parole doesn't change that the advice was erroneous. It just changes perhaps the reason that the advice was erroneous. But to the point about whether or not this is collateral, this is the second conflation I wanted to address very quickly, is the difference between affirmative misadvice and lack of advice. Counsel doesn't have to provide advice on parole. That wouldn't be ineffective assistance if she didn't provide any advice of parole. When you affirmatively provide advice that is wrong, that, under the cases I've cited, even on a collateral issue, may support an ineffective assistance claim if the client relied on that misadvice in deciding to tender his plea.
So let's assume that we don't buy the motion to suppress argument. If we agree that it was deficient performance to advise as she did on parole, which of the Clark prongs is most applicable here? I don't see how this created an otherwise available substantial ground of defense. I'm not quite sure how it raised the possibility of a more favorable plea, and I'm not sure I see that the Vermont cases present special circumstances. If anything, he would want to be here longer, so he could at least get treatment before he had to go off and face the charges in Vermont.
So I believe the two latter prongs present the strongest argument. A better plea deal could have been negotiated. In counsel's affidavit, she points out that prior to her, Mr. Tinan had prior counsel who's negotiating with the Berkshire DA, who suggested a plea of with an incarcerative portion of 4 months.
Right.
He ended up with a plea with an incarcerative portion of 18 months, and so that suggests that a shorter plea could have been negotiated. Mr. Tinan, in his affidavit, states that if he had been advised that there's a substantial likelihood that you'll serve the entirety of the 18 months, he would not have agreed to tender his admission to a plea with a suggested disposition of 18 months. The Vermont cases amount to a special circumstance because Mr. Tinan knew that he was facing liability there. He was certainly concerned in his affidavit. He expresses a concern about the total amount, the cumulative time that he would serve between those two jurisdictions, and especially because that there was no global resolution here. Mr. Tinan was very much concerned about the length of the time he would serve in Massachusetts, and then the potential that he would have to serve essentially a consecutive term in a different state, in a different jurisdiction. So I would suggest that it's those two prongs as to the parole, issue.
Seeing no further questions from my Other members of the panel, thank you for your argument.
Thank you.
We'll hear from the Commonwealth.
Thank you. May it please the Court, Lori Levinson from the Berkshire District Attorney's Office on behalf of the Commonwealth. The question that's really before this Court today is not a de novo review of the likelihood of success of the motion to suppress. It's whether or not the hearing judge on the motion for a new trial abused his discretion in denying the motion for a new trial. And the Commonwealth's position is that he certainly did not abuse his discretion in denying the motion for a new trial for any number of reasons, one of which is the fact that the hearing judge, after having the entire record that is before this Court, determined that a motion to suppress would not have been successful.
That involves legal determinations that we would review de novo, doesn't it?
Oh, yes.
Such as, and I'm reading between the lines of his decision, he agreed that the area wasn't curtilage. So if we were to disagree, number one, what kind of question is that, as I asked defense counsel? Is that question of law, question of fact, mixed? And then if it's a question of law, couldn't we reach a different?
Well, I do agree with counsel that it definitely has to be a mixed question of fact and law, because every case, well, I can't say every case, but most cases involving curtilage are very, very fact-specific, and the Court has to look at everything surrounding the area that is under consideration to determine whether or not it is curtilage. And in this case, I think it's pretty clear that this detached garage at the end of the property was not curtilage, particularly with respect to Mr. Tynan's. Again, I think it was you, Justice Sachs, who mentioned the expectation of privacy issue. Did he have an expectation of privacy in that bay of the garage?
Curtilage and expectation of privacy seem to me to be two different inquiries.
They are.
Okay.
They are.
So maybe you could address the curtilage part first.
Okay. On the curtilage part, as you know, in a multifamily dwelling situation, a tenant's curtilage is much more restricted than in a single-family home. And I think one of the most telling facts in this case about that detached garage not being curtilage is the fact that you have the path running past the doorways of the house towards the back of the house, where you do have mailboxes and entrances that you would expect the public to be welcome to, and a police officer if they were coming to make inquiry. But then you also have what looks like a fairly public parking area in front of the garage. It's a quite large parking area in front of the garage that is clearly visible from the street. There was no fencing around. There was no gate, showing that people should not be entering this property. It was wide open, and the fact that we have the path next to the house separated from by some greenery, and then we have the driveway that leads to this wide open parking area in front of the garage, leads to the conclusion that this was not the curtilage of Mr. Tynan's third-floor apartment in this multifamily dwelling.
And if it's not curtilage, what do you say about reasonable expectation of privacy?
Then I say he has no reasonable expectation of privacy in a 5-bay garage where multiple tenants, multiple people have access to that garage. There was some, I think the records show that there was a chair in one of the bays of the garage. There were other cars in bays of the garage. So again, Mr. Tynan upstairs in his third-floor apartment, we don't even know if this was an assigned garage space. Could he have parked in the driveway? Could he have parked in the garage? I don't believe that the facts show that he had a reasonable expectation of privacy in that bay of the garage. And then I also, since Mr. Madison ended on his argument about the parole eligibility. The case law in the Commonwealth is just so clear that misadvice as to parole eligibility is a collateral issue.
This isn't advice about eligibility. It says you're virtually certain to get parole after 9 months or after half your sentence. Isn't that different from saying you may be eligible, and of course, we don't know what the parole board will do?
Well, it's not that.
And isn't it just like advice about here's, you know, if you take into account good time, here's what you'll actually serve?
Well, again, that is advice that is virtually impossible for a lawyer to really give, and also for this.
She says in her affidavit, she talked to 2 representatives of the parole board who are out at the Berkshire House of Correction. So we don't really know the content of that. We don't know if she said, well, what about this regulation that creates the strong presumption against parole if you got a detainer? And they might have said, well, in his case, it's not an issue.
Well, the defendant also knew that he had a detainer in Vermont. He knew that he had to answer to Vermont, which goes back to her strategic decision to keep him in Massachusetts.
But he may not have known about that regulation. So if we're talking about deficient performance, saying, you know, you're virtually certain to get parole after 9 months, and he doesn't know about the regulation, could that not be deficient?
I don't think it is deficient, again, because parole is
yeah.
a collateral consequence, no matter.
Let me jump in for a moment and just get some clarity. Parole eligibility, the case law is clear, is collateral. Okay. Case law is not clear that virtually certain to get released is collateral. And so I would agree with you, counsel, if your position is attorneys ought not predict the future. Because counsel's advice about virtually, you know, going to happen was also predicated on the fact that Mr. Tynan would get into a substance abuse program and had no concept, like the rest of us, that COVID would come in and completely obliterate any opportunity for these things to occur. So, when we look at the cases and take Padilla out of this equation about collateral, is this not equivalent to trial counsel say, let's go to trial. I'm virtually certain you're going to get a not guilty. Jury comes back, guilty. What do you say about that?
Well, I would clearly say that that's not ineffective assistance of counsel. That is counsel's reasonable belief based upon counsel's review of the facts and the law of the case that it was, in counsel's mind, virtually certain that a not guilty verdict would be obtained. But of course, nobody can possibly predict what a jury is going to do. And just like—
Is that similar to the parole board? No one can possibly predict what the parole board will do?
That is true. No one can predict what a parole board is going to do. And if counsel's saying that you are virtually certain, I mean, are we just like really picking apart that word virtually certain? That could mean probably. It might not mean 100%. She didn't say, you are getting out after 9 months. She said—
Well, if she'd said that, would that be deficient
I still don't think
in
it's—
circumstances?
I still don't believe that would be deficient under the jurisprudence in this Commonwealth, that parole, that anything to do with parole is really collateral, because that is something that is not within the control or of anyone other than the parole board.
But leading someone to believe that somehow, in making a statement that this is virtually certain, maybe leading the client to believe that it is within the control.
Well, that's true. I mean, this client probably believed that he was virtually certain to receive parole, but again, this is a person who had been incarcerated for over a year over in New York State, apparently knew a little bit of something about how incarceration works, and virtually certain doesn't mean, I will tell you that at the 9-month mark, you're getting out.
So it's not erroneous
Okay.
advice at all?
Excuse me?
So you're saying it's not erroneous advice at all, it was a prediction?
Exactly. And it was an affirmative prediction that turned out to be incorrect, but it doesn't amount to ineffective assistance of counsel. And you would also, if you're looking at whether counsel was ineffective, you have to look at everything that she did. I mean, she talks in her affidavit about how she actually reviewed CLE materials on parole.
Sure, she did a lot. But if she was wrong about this, it seems to me to be wrong about how much time he's going to serve. I don't really see much difference between this and saying the maximum sentence you could receive on this is 9 months, when it's actually 18 months. She was effective, or certainly very thoughtful and strategic in a lot of other things, but she may not have been in this instance, where it directly affects the time that he would serve. I'm still not persuaded it's collateral. If you want to move on to something else, fine. If you have other responses, love to hear them.
I'm trying to think of what I can say to persuade you that it was collateral, but I think that my brief does cover that. So I would just like to touch briefly on counsel's very effective and novel representation of Mr. Tynan, and that her decision to forego any investigation and filing any motion to suppress was a very manifestly reasonable tactic to take under the very particular circumstances of this case.
Before we leave the parole advice issue, assuming that we were to decide that her advice on that was deficient, then what about the prejudice? And I asked defense counsel about which of the 3 Clark prongs was most applicable here, and he started out with prong 2, the better plea agreement could have been negotiated. Can you address that? And defense counsel, the trial counsel here said, yeah, I knew there was some talk of a 4-month sentence. I didn't think that a court in Berkshire would do that, but there's a lot of room between 4 and 18.
Well,
what would a better plea agreement have been possible here? She went for 18 because she thought he had to be there for 9 to get the treatment.
exactly. And I mean, she was very, very careful in her research into how much time he would need to be sentenced to in order to benefit from the residential drug treatment program. And the 18-month sentence, which he agreed to, and apparently, according to plea counsel's affidavit, was discussed among and by the defendant's mother, Vermont counsel, and herself, all agreed that treatment was of paramount importance and that a sentence of sufficient length to obtain that treatment would be necessary. And counsel's strategy was to keep him out of Vermont's hands for as long as it took for him to position himself in such a way that when he finally was presented to the Vermont courts, they would relent on this extremely harsh sentence.
But is it clear that a better plea agreement wasn't possible that would have gotten him the treatment in this RSAT program, but still have had him serving less time?
It's not clear that a lesser sentence would have been sufficient because she, when I say she, plea counsel, did communicate with people at the jail, the people who ran the RSAT program, to find out what kind of sentence would be necessary. And I'm not, this may be outside the record, I'm not 100% sure if it's in her affidavit, but you have to have a certain amount of time in your sentence to be evaluated for the RSAT program, then for a room to open in the RSAT program. So you need some bumper time.
All right, but why not a year or a year and 3 months? Given the openness of the ADA reportedly to a 4-month sentence earlier on, and the need for 9 months for treatment and maybe some time for evaluation, wouldn't something
I
more
think
than
that-
4 but less than 18 have been plausible?
I think that's a little bit outside of the record because we really don't know from the record what her conversations with the RSAT program were and the people at the jail and what they advised her as to the amount of time that would be necessary. But I think we might be able to infer from the tremendous amount of work that she did to ensure that Mr. Tynan would get the treatment that would position him well in Vermont, that had to have been taken into consideration by her in developing this 18-month sentence as opposed to a year or 15 months.
And if we're not sure, is it appropriate to send it back for an evidentiary hearing?
Well, I would suggest that the Commonwealth, of course, would prefer this court to send it back to an evidentiary hearing rather than to grant Mr. Tynan's request for a new trial in this case, to take testimony on that issue. But I don't think it is necessary if we look at the whole record and look at whether or not, the real question is, was counsel's strategic decision manifestly unreasonable at the time that decision was made? And I believe that the record is quite clear that it was manifestly reasonable because of the global position that this case was in.
Seeing no further questions from the rest of the panel, thank you for your argument. Thank you both,
Thank you.
and we'll take it under advisement.
Thank you.
In our next case, we'll give counsel a little bit of time to pack up, but our next case will be 23P296, Christopher DiGiovanni versus Richard Arenson and others. And be seated, please. Just so we're clear, the counsel for Mr. Arenson is arguing first for 5 minutes, yes, sure. And then counsel for Mr. DiGiovanni for 10. Okay. All right. We're ready when you are, counsel.
Thank you, Your Honor. May it please the court. For 46 years, Richard Arenson has dedicated himself to the estate planning goals of his clients without any complaints, except this one. Many of his clients become like family, so when Mary DiGiovanni, who was the settlor of the trust in this case, asked him to become successor trustee with Stephen, he agreed to help navigate the trust through a difficult time. Understand that the key issues here happened in 2008, a very difficult time for any kind of real estate transactions. By December 2007, when Mr. Arenson agreed to become successor trustee, the loans were coming due. Stephen had been unsuccessful in finding replacement funding other than this potential loan from Bank of Canton. The issue, as Richard was informed, Richard Arenson, was the Bank of Canton only agreed to the loan under very specific terms. And that was putting the projects under the control of a fellow by the name of Richard Simoni.
But that's not what the judge found, right?
He did not. On the other hand, there is absolutely nothing in the record to suggest that Richard Arenson knew anything other than what he was informed by Stephen DiGiovanni and Mr. Simone with regard to this loan, that was a key factor. They would not make the loan to Stephen DiGiovanni. They would make the loan if Simone was in control.
Did the judge make a finding about Mr. Aronson's knowledge of what was required?
He did not. What he did say, and I know the standard for factual findings is clearly erroneous, but he said that there was nothing in any of the loan documents to reflect Mr. Simone's involvement. And that is plainly wrong. In my brief, I cite to the loan commitment letter, which is written to BSC Truro, which is the LLC of which Mr. Simone was the manager.
The question isn't whether he was involved.
I'm sorry?
The question, it seems to me, isn't whether he knew Mr. Simone was involved, but rather whether he had reason to believe from documents or otherwise that the bank was actually requiring Mr. Simone to be made manager of this new entity to which all of the trust property was assigned or transferred. Involvement versus control.
There is nothing to contradict the testimony from both Stephen DiGiovanni and Richard Arenson that Mr. Arenson was informed that the bank was requiring that Simone be in control of this transaction.
And Mr. Aronson was informed, if I have the testimony right, by Stephen, who in turn said, Simone told me. Shouldn't that be a red flag? Stephen didn't communicate directly with the Bank of Canton, as far as we know. Stephen was relying on what Simone told him.
The evidence is what the evidence is.
Well, is that the evidence, or do I have it wrong?
Forgive me, Your Honor, I didn't try this case. But my understanding was that Simone was the primary contact with Bank of Canton, that relationship was already established long before any of this occurred, and that it was Simone who made the arrangements for the Bank of Canton loan, which was critical to the trust surviving at all. Otherwise, they were subject to foreclosure. So when Aronson came into this, there were two choices, the Bank of Canton loan or foreclosure. And the Bank of Canton loan, to the best of his knowledge, and without anything to contradict what he was informed of, was requiring Simone to be in control of this transaction.
And you say it was reasonable to rely on Stephen's representation that Simone had told Stephen that the bank insisted that Simone be in control? That was reasonable for Mr. Aronson?
Well, it was. Stephen had been controlling these trusts and these projects from the get-go.
But where you're an independent trustee, don't you have some responsibility to verify very important facts yourself, such as who are we assigning all the trust property to?
Well, and so he
And why?
asked. And Mr. Simone, at the time, was an attorney of...
Well, he didn't ask Mr. Simone in advance. He didn't meet with him in advance, I thought the testimony.
No, he spoke with Stephen DiGiovanni, who'd been running the project, who knew Mr. Simone.
Counsel, isn't there a purpose for an independent trustee? It seems to be that the entire brief is indicating that he relied on Stephen. But it seems to me that he had a separate role from Stephen. He was supposed to be independent and not simply rely on Stephen. That was the purpose of him being an independent trustee.
The roles of the trustee are established under the terms of the trust. There is an exculpatory clause that a trustee is not going to be personally liable for anything but his own bad faith or intentional misconduct, neither one of which apply here. And that at the time that Mr. Aronson was named co-trustee, Stephen was operating the entire project and had been all along. So there was no one else to rely upon other than to look at the documents themselves, and the documents were addressed to Mr. Simone and required his guarantee. So you have Stephen DiGiovanni.
Didn't require him to be in control.
They don't use those words, no. But the commitment letter is addressed to BSC Truro, in which it was already, he was in control.
And has an integration clause.
I'm sorry, sir?
And the commitment letter has an integration clause. says, you know, this supersedes any other oral representations, this is the whole deal.
Correct. So Judge Wilkins didn't believe Mr. DiGiovanni, quite simply. But there's nothing to say that Mr. Arenson had any reason to question what was being reported to him by Mr. DiGiovanni in this transaction. And given what Mr. Simone's role was at the time as a developer, as attorney who'd represented Christopher, he'd represented Stephen, he was a longtime friend of the family, there were no red flags for Richard Arenson to be concerned about Mr. Simone coming in.
Can I just ask you one more question about that? Even if there was no red flag when the assignment of managerial control and the properties occurred, Mr. Arenson testified that within a year or two after Mr. Simone came into the picture, Mr. Arenson was aware of several of these, that Simone was mortgaging the trust property for purposes that had nothing to do with the trust. And he spoke to Stephen about it according to his testimony and said, you got to get rid of this guy. But Stephen didn't, and Mr. Arenson stuck around for another 4 or 5 or 6 years, depending on when he learned. But he learned in maybe 2010, 2011, and he stuck around until 2016 without really doing anything to make sure that Simone was taken out of the picture or relieved of the control that he had.
Well,
Isn't that reckless indifference? I mean, being aware of a risk like that and going forward?
Richard Arenson wasn't aware of anything in advance of it occurring. And that is very clear in the evidence. Mr. Simone had already done the things he did, which the trickle-down resulted in damages to the trust, before Richard Arenson had any notice of any of those things. Now, the only thing to do at that point when he did become aware would have been to try to remove himself or to try some other legal action, but a legal action would have had to be made against Stephen, and Stephen was also a beneficiary who was still running these trusts, doing the real estate development, and investing a lot of his own money. So, as Mary DiGiovanni's attorney, and trying to serve the best interests of the trusts, that would have been contrary to Mr. Aronson's ethical duties. This is blinking at me.
Any further? All right, your time is up.
It is indeed.
Some
Thank you,
extra,
sir.
and-
I would rely on my brief, obviously, but also bring to the court's attention that in the event that Mr. Aronson is cleared, there is a motion for fees because all of this is against him as trustee. Thank you.
Thank you.
Good morning. May it please the court, I am Edward McLaughlin. I represent Stephen DiGiovanni, who is the defendant appellate in this matter. Picking up on what Attorney Cashier was just touching upon, I think the crux of this case falls in the finding against my client and against Mr. Aronson that, in fact, they intentionally, violated the terms of the trust, created a breach of trust by including Mr. Simone, is at the crux of this case. And again, as counsel said, let's go back to the commitment letter. The commitment letter is addressed.
Can I interrupt for a moment, counsel? If we were the trial judge, that would be a great argument, but we're not. And isn't that a credibility determination that the trial judge made after a number of days of a jury waived trial about whether it was an intentional act or not? So our review on the facts are clearly erroneous.
Well, again, I would get into clearly erroneous facts, of which there are some. But sticking with the Bank of Canton, again, as in any commercial real estate transaction, the bank controls all of the documents. So when Stephen and Mary DiGiovanni and Mr. Simone and Mr. Aronson went to this closing, the bank produced every single piece of paper And if you look at the record, all of those documents are there. They are all notarized by attorney William Grenier, who represented Bank of Canton. He reviewed the management agreement with Mr. Simone. He reviewed all of the documents. He notarized all of the documents. That's what the bank required. Everyone has gone to a closing and found in the usual packet of documents, the bank has come up with one more document. The borrowers have the option, if you sign this, we'll grant the loan. If you don't get the loan. So again, all of these documents were created by the bank. The bank could have, if they relied on my client to be the manager, he was already the trustee of the trust controlling 2 and 4 Mary's Way, and the other trust controlling 1 and 3. They could have made him the manager of a new LLC and continued on. They didn't, because they had a prior relationship with attorney Simone, who was a real estate developer who had outstanding loans with the bank and was known and trusted. So all of that makes sense. And again, Mr. Simone went to high school with my client at St. Sebastian's. He was known to the family. He did a closing for Christopher.
But all of those facts would equally tend to indicate that maybe it was an idea that Mr. Simone came up with, not being required by the bank, but...
At the time, Stephen and the trust were hanging by a fingernail. Mary DiGiovanni had been cut off. Louis had died. The husband had died. She was cut off from funds. Her $10,000 a month was gone. She had no access to funds, and Christopher and Stephen were in a position of supporting her and were desperate for loans. At the same time, Louis's estate was demanding $960,000 in estate taxes to transfer property to her. My client, along with counsel for Mary, engineered this deal, which was financed by Bank of Canton, which for $800,000 in settlement funds, they received title to 2 and 4 Mary's Way, which were worth $3.5 million at the time. A fantastic investment. Again, the Bank of Canton loan was the last resort, and the bank wouldn't do it without Mr. Simone being involved. And at the outset, having known him all his life, there was no reason for he or Mr. Arenson to doubt Mr. Simone.
Well, he took Mr. Simone's word for it that the bank was requiring Simone to have complete control.
The commitment letter says they're going to approve a management agreement. The management agreement wasn't necessary if Stephen was going to be the manager, because he was always the trustee of both trusts.
But it doesn't say, the management agreement, as described in the commitment letter, doesn't say what level of control Mr. Simone is going to have, or what kind of reporting he needs to do, or approvals he needs to get from the trustees.
All of that was in the management agreement. Again, which was done at the closing, approved by the bank.
But is there evidence that the bank was requiring that particular management agreement? Or those terms?
I mean, the court found that Stephen could not, and the trust could not obtain a loan on their own. So there was no evidence that there was any other loan out there. Let's remember, the judge makes sort of light, I think, of the downturn of 2008. This loan was closed exactly 6 months to the day before everyone that worked for Lehman Brothers in New York walked out of Wall Street with their desk in a box in their hands. This was a miracle that the Bank of Canton granted this loan. This trust probably should have been bankrupt in 2008, but because of contributions from my client and his wife, and a couple of small loans, and all of the loans from Mary, he was able to develop the project. Let's not forget that this trust started with 2 properties, 1 and 3, that were all encumbered, of little or no value, and today we sit here with $1.6 million in an escrow account through all of the downturn and all the problems. You know, again, the award of damages is illustrative. If you go through the court's award of damages, the first error that I can point to is the fact that he attributes a transfer of funds in the amount of $1.1 million as a repayment of a loan to Mary. Now, he makes a finding that she contributed $2.5 million to the construction of these houses, and that's the bulk of the construction money, and that was his finding. If you take out the 1.1, there wasn't sufficient money. There was no other source of funds. There were two small mortgages. There were the contributions from my client's ATM company along with his wife, and there was Mary. If Mary was repaid this loan, then these houses couldn't have been built. I mean, factually, that is totally inconsistent. And again, this case was brought to the court because of all of the things that claimed that my client did wrong to harm the trust, that he built houses that were too extravagant, that he built basketball courts and playgrounds and the rest. In fact, he did, and the real estate broker that testified for him said that it was consistent with houses in the area, and that it was always marketed to be sold.
And the judge didn't find that those investments or those transactions were reckless or
exactly.
indifferent or intentionally harmful to the trust. Those particular ones. Really what the judge focused on primarily was the delegation of control to Mr. Simone, and then the two loans, the Mohan transaction and the Essex condo, which according to Mr. Arenson, your client, Mr. DiGiovanni, knew about within at least a year or two after they happened, and yet didn't take steps.
In 2011, Mr. Simone resigned his position he was out of the thing in 2011. So again, at the time they made the decision to take this loan, which included Simone, no one had an inkling that Simone would do anything wrong. I mean, this was a fine, upstanding attorney, real estate developer known to the bank. The bank trusted him. Again, and as I say, my client and his mother were the only two people that weren't lawyers at this closing. So again, the bank created all these documents. If they wanted my client to be in charge of the project, the paperwork would have said that. It didn't. As you go through these damages, Mary, in Exhibit Record Appendix 4-183, Mary, in the end, was owed $869,000 that was never repaid. So the judge's award of damages for her care, when my client paid for her care to the tune of $494,000 or $474,000, should be characterized as a repayment of a loan, along with the $92,000 that he finds as an overpayment to her. So once you subtract those, you then come to what's called the Wainwright holdback. And in fact, post-trial, the court was given two bank statements. The court contended that $200,000 was not released by Bank of Canton on the Wainwright holdback. In fact, there were two bank statements that showed the loan of $3.2 million with the $700,000 holdback, and then the following month, the $300,000 fully distributed. So again, the $200,000 was paid out. It was paid back. These loans were all documented. If you can fault my client, he didn't do a written accounting for his brother. But again, remember, any harm that he would bring to the trust would affect him 50%. There's no reason. He's the person that kept this thing alive from 2004 to the present day. And the judge's findings just are clearly erroneous. You cannot say, for example, in the testimony of the broker, that construction supervisors get between 20 or a management fee of 20 to 35%. My client on the last house charged 15%. The first three houses, they paid 25%. He saved the trust 10%, but nonetheless, the judge found that was excessive, based on no evidence.
Well, didn't the judge specifically find that he wasn't really acting in that capacity? So there wasn't a justification for the fee?
Well, I mean, the judge seems to think in his findings that a management fee encompasses that you do all the work. As we know, management companies, hire snow plowers and cleaners and maintenance and repair people. The management fee doesn't cover all of those expenses. Again, the judge faults him for that. The accounting was good enough for the court to make a finding that, 12 years ago, he made a $2,400 payment for housing for his brother, and that wasn't part of the terms of the trust. It's that, we admit, that and a $10,597 charitable contribution we made, again, he can be faulted for that. But the balance of the damages just are totally unwarranted here. The exculpatory clause should control the day. I mean, willful, I think the best definition I've ever had of willful conduct is it is willful means a knowing violation of a violation of a known legal duty with a bad purpose. Negligence, even gross negligence, is not sufficient. And in this case, you might find that my client was negligent. He's been criticized for not filing reports of the trust and tax returns. As we all know, the tax returns we think is a red herring. The tax returns aren't due unless there's income from the trust, and there wasn't over all these years.
Just going back to the self-dealing that the judge found in terms of paying himself fees, is that subject to the exculpatory clause and the reckless indifference standard, or is that just ordinary breach of fiduciary duty?
I think it is subject to, because, again, he worked all of these years. He never took a distribution. Christopher never took a distribution. Until 2021, he repaid himself for the work that he and his wife had done. Realize these two people loaned almost $2 million.
Well, he might have been entitled to something. I guess my question is, what's the legal standard by which that's evaluated, what he paid himself versus what he might have been entitled to? Is it reckless indifference, or is it, since he's dealing with himself rather than making some
I think it's reckless indifference. Again, the exculpatory clause covers, I think, any distribution from the trust. But again, I represent to the court there's no bad judgment here. Other than Simone, and Simone admittedly cost the trust $900,000. Half of that came out of my client's pocket directly. Because whatever happened, if there never was a case, he would have had to suffer half of that bill. If he had known that at the time he got involved with Simone, he never would have done it, obviously.
Okay. Thank you. Seeing no further questions from the panel, your time is up. Thank you for your argument.
Thank you, Your Honor.
And we'll hear from the other Mr. DiGiovanni.
Good morning. May it please the court, my name is Karen Friedman. I represent the plaintiff appellee, Christopher J. DiGiovanni. I'd like to just dive right in on the transactions with Mr. Simone. One of the things I'd like to discuss that I don't think counsel has really covered is the clear violation of Section 12 of the trust, the delegation provision. It allows, it says the trustees may delegate to any one or more of their number the power to sign checks, draw on bank accounts, and execute a variety of legal documents. They're allowed to perform any legal acts for or on behalf of the trust. On the other hand, non-trustees are only permitted to be delegated to ministerial and administrative functions. But Simone, as a non-trustee, by virtue of his appointment as manager, was provided with the type of powers that are only granted to a trustee. And in fact, he was granted sole control because he was the only manager. The LLC gives him the right to exercise all of the LLC's rights, powers, duties, and responsibilities, and that included the power to purchase, sell, convey, mortgage, pledge, encumber any of the trust, any of the LLC property.
It certainly seems like delegating such control to a non-trustee who's not subject to fiduciary duties to the trust and the beneficiaries could raise the prospect of substantial harm to the trust. Does such a delegation entail a high degree of probability that substantial harm would result?
I think, yes, I believe it does. I believe any time that you, and I think the case law supports this, if you take trust property and you put it beyond the control of the trust or you as trustee, and you no longer have legal control over that property, and someone else does, and they have unilateral sole control, there's a very high probability, it is foreseeable, that substantial harm could come to that property.
Without regard to who it is?
Yeah, I believe so. One thing I want to point out, Your Honors, is
Do you have
that...
a case that says that?
No, now, and I want to address that. The cases that the court relied on, but also the defendants, appellants relied on, Manning, Rafferty, Boyd, all of those cases are tort cases. They are wrongful death cases, they're social host liability cases, and in those cases, the idea that there has to be, a high probability of substantial harm and a recognition of that on the part of the potential tortfeasor makes sense, because in those situations, these people could be strangers to each other, and there's no pre-existing duty. But here there is a pre-existing duty, and it's the highest duty that is recognized by the law. It's a duty, it's a fiduciary duty, it's a duty of utmost good faith and loyalty, of, prudence, reasonableness, skill, judgment, all of that. So I think, the risk assessment on the part of a trustee needs to be a little sharper than it might in an ordinary situation where, you have to foresee that the way you drive your car might injure somebody, or serving them too much alcohol might cause them to cause an accident.
But are you saying that standard doesn't apply in determining recklessness?
I think it does apply here. I mean, I think it's met, but I also think it's worth considering the fact that we are talking about trustees, not strangers to each other.
So obviously substantial harm could result if the non-trustee goes off and mortgages the trust assets or conveys them. But again, the question is high degree of probability. What do you think are the best facts in this case, or the factual findings in this case, that support a determination of high degree of probability that Mr. Simone would do those things?
The fact that Stephen DiGiovanni already knew about these transactions. In fact, there were 3 transactions: the Newton house flip transaction, the Mohan loan and mortgage, and then the Essex condominium purchase. The Newton transaction was aided and abetted by Stephen. I mean, he signed the loan documents. He gave Simone permission to do this.
The judge didn't find harm from that,
And there wasn't.
Okay.
There wasn't.
And did those occur far enough in advance of the 2 transactions that did cause harm, that they put Stephen on notice that Simone needed to be controlled?
There were several months before.
And where would we find that?
I need to think about that, Your Honor.
Well,
The Newton, let me.
if you want to, I don't want you to spend your time searching for
Yeah,
sites.
I'm sorry.
You can send
I'm
it.
sure it's in here. I just like zeroing in on it. But they were, but the other thing is,
Did the judge rely on those facts, though? I mean, were there findings that he knew about the Newton transaction in advance of when he knew about or in advance of when the Mohan transaction and the Essex condo?
yes, I believe there were. The other thing about Mohan is that he did find that Stephen knew about the Mohan transaction before it transpired. And the importance of the Newton transaction and the Mohan transaction together is twofold. One, it's a signal to Stephen that Richard Simone may not have the financial wherewithal that he believes he has. Otherwise, why is he coming to the trust to use trust property for collateral for his own business purposes? I mean, that should have been a red flag to Stephen immediately at the first transaction. The other thing is, I think, it kind of establishes a pattern. Perhaps Richard Simone thought it was okay to do this. Stephen said okay twice, so he, later on he goes on and buys the condominium. One of the things that The other important factor to keep in mind is the fact that there were no guardrails, and there was no monitoring, and there was no mitigation of any of these transactions. So there's no guardrails. They neither Stephen nor Mr. Arenson ever seek to become co-managers. There's no apparent reason why they couldn't do it. Stephen at some point just says, oh, I just didn't see the need to. They don't monitor him. Stephen testified that he never asked Simone for evidence of payment. You know, he's not keeping up with this.
Lack of monitoring could be at least negligent, but the question is, does it rise to the level of recklessness outside, you know, so that it's not protected by the exculpatory
I would say
clause.
that if someone has taken out a $400,000 something loan and has secured trust property with
And
it,
if you don't do something, it's worse than
then
negligent.
I think you're obligated as a trustee. You must keep track of your property. Your duty, one of your primary duties, is to protect trust property.
What about Mr. Aronson? I mean, your argument's primarily directed to Stephen, but did Mr. Aronson know about the Newton flip before any of these other transactions occurred, or have additional reason to suspect Mr. Simone's conduct?
2 points there. One is that Mr. Simone had no real reason, no good reason to believe that Mr. Simone was a good candidate, right? He knew nothing about him. He did not meet with him beforehand. He did not talk with him beforehand. All he really knew is that he was a lawyer that Stephen was familiar with. So this is not someone who's been vetted and whose credentials have been examined, or someone that he's even familiar with. And it's certainly not some, Fidelity Bank or State Street Bank and Trust. He doesn't know what Mr. Simone's assets are. He doesn't know.
Are you saying Mr. Aronson had a duty to inform himself of these things?
Yes, absolutely. Absolutely. And the other thing I want to point out is that this loan transaction is taking place in March of 2008. Mr. Aronson has been trustee for a few months now, several months. He has not seen a single financial for the trust. Everything he knows about this trust is based on Stephen's representations, including the bank's requirement that Mr. Simone be manager of the LLC. I mean, that's just like double hearsay. He didn't speak to anyone at the bank. Stephen told him, and Stephen testified that Simone told him, the person who's going to benefit from being the manager. I mean, those are several red flags right there.
But with respect to Mr. Aronson and his liability or culpability, simply, does the exculpatory clause apply if he simply just doesn't do anything?
Yes. Those are bad actions by omission. Those are reckless. That's reckless by omission, by just standing idly by and letting something happen, because he was aware. He testified that he found out about these transactions from Stephen a year or two after they happened. And that caused him to advise Stephen to get rid of him. It is while he is still trustee. But he takes no action.
But had the harm been done at that point?
Yes, but there's still monitoring that could take place. He could be, if he had informed himself about the Essex condominium, there is potentially settlements that could have taken place to mitigate the amount of harm, and then they could go after Simone for whatever they were out of pocket. But they do nothing.
I don't recall the judge in his discussion of recklessness relying on the knowledge that either the defendants obtained of Mr. Simone's activities and then their failure to do anything. Maybe I overlooked it, or did he not really rely on it?
I'm sorry, Your Honor, I just
Did the judge rely on Mr. Aronson and and did he rely on the defendants having learned about Mr. Simone's transactions with the trust assets and not doing anything? Response? Or
yes.
Did he more rely on the delegation itself to Mr. Simone?
No, I think, he was equally concerned with the failure to monitor and the, in connection with the duty to supervise, trustees' duty to supervise their agents. And I think, let's see, this is all testimony, but I think, I think on my addendum, the addendum to Christopher's brief, I think it's pages 172 to 173, but the court, in its amended findings of fact, did have a fairly substantial discussion about the failure to monitor and the duty to supervise.
I don't want to jump around too much, but Stephen's reply brief at pages 13 to 14 says that your brief makes an important concession about the amount that Mary loaned the trust, and that it included $967,000 from Citizens Bank. And I just wanted to hear if you had a response to that.
No, that's not a concession. And that was before the judge as well. I had raised that in, I believe it was post-trial briefing. And it was in response to the impossibility argument that there was no way these houses could have been built if she hadn't loaned all that money. But that was a loan that had been paid off in part by the, I think, one of the Countrywide loans. So it was really the residual amount on that was added to that chart. So, I mean, that was taken off the table beforehand. It just wasn't part of those loan amounts. It had previously been paid off. Okay. And the other, the one thing I want to point out is the Mary's payments and these accounting issues are all a result of Stephen's really poor record keeping, and the fact that he did not create records until years later. There were no profits and losses created contemporaneously. There was commingling. No one's talked about commingling, but all of the money from the mother's property, which was in a separate trust, and the properties from BSC Truro, and then all of the DFIT properties, all of the money, all of the rent, all of the loans went into the same account. All of the expenses came out of the same account. There were no separate accounts. So it really made sorting through this very difficult.
I did have one further question. Mr. Simone individually guaranteed repayment of the $3.2 million loan to the Bank of Canton.
Yes.
Should that be taken into account? And did the judge take it into account in determining whether it was reckless to give Mr. Simone the level of control he had? Or he was personally on the hook, so why should they think that he's going to go off and do something reckless with the assets?
Well, I guess I have two responses to that. One, he was paid $162,000 for doing it. But two, the bank has substantial collateral. I mean, it has a mortgage on 4 1-acre plus, beach-adjacent properties, 3 of which have very, very large luxury rental homes built on it. I don't know how much, actual risk there was. I suppose there was some. But, why would he do it? I don't know why he didn't testify. I don't know why he would take that risk. But I'm not sure it was as great a risk as has been suggested.
All right, seeing no further questions, thank you both for your, thank all 3 of you for your arguments.
Since I have a minute and...
Sure, well, everyone else has had some extra time, so.
Oh, this is not extra time?
The other way.
This is now, your deficit is mounting, but go ahead.
All right. I will finish up here.
All right.
Great. Thank you, Your Honor.
Thank you. That concludes our sitting for today, and we will be in recess.
All rise.